All rise. The Arizona Court of Appeals, Division 1 is now in session.
Please be seated. Good morning. We're here in our case CA CV16-002 White versus Anderson State. Each side will have 20 minutes to present their argument. Apparently, you may save time for rebuttal, but you're going to need to keep track of that time yourself. We have the clock at the podium for that purpose. We're recording the argument both in audio and video, and you'll be on YouTube in a few days if you want to watch the argument again. And because we're recording it, please identify your client and yourself when you begin. We've read the briefs and looked at the record and conference the case, so we're familiar with the arguments. So when you begin, just launch right into what you want us to know. Counsel, you may begin.
May it please the court, Appellant Kara Jo White, my name, for the record, James David Smith on behalf of Kara Jo White. On behalf of Appellant, we are requesting that the Court of Appeals remand the lower court decision to decline jurisdiction regarding Appellant's petitioner's special action request. And I won't go, very briefly, I will let the court know. Defendant, currently appellant, petitioner, Kara Jo White did file a motion to suppress in the West Mesa Justice Court in 2015. That was denied. The issue there was what is or should there be some minimum objective indicia of intoxication, impairment, something to allow a police officer to start FSTs. We know that under a totality of the circumstances analysis that an officer needs to have reasonable suspicion, but Arizona...
Well, okay, so why, the question I have before we get to the merits is why don't we consider this issue, or why should the issue be considered on appeal after your client is possibly convicted rather than now on a special action?
Your Honor, because the special action petition urged the lower court to exercise its discretion, and it did decline it. Correctly? You're correct? It did decline jurisdiction. However, in its order, in its ruling, it did not provide substantial support for denying jurisdiction. It merely addressed the fact, as this court has already asked, doesn't appellant have some remedy if she were to go to trial and lose or submit on the record?
If you and your client have a point, can that be resolved on lower court appeal? I mean, your client may not even be convicted, I take it.
That, hypothetically, my client may not be convicted if she were to go to trial. That would be her own.
And if that's the case, why would we need to consider all this?
Because this is a matter of statewide importance. It is a purely legal issue with a complete record that has been brought, that was brought to the lower court of appeals. And given the fact that it's purely legal. It's a complete record, and it is of statewide importance. It's in the realm of driving under the influence cases where tens of thousands occur here in Arizona. The lower court could provide some guidance on an issue that is completely, there is no guidance currently.
Well, I didn't think that lower courts issue decisions to give guidance. Their job is to decide the cases before them.
Ms. White would then be forced into a trial at the West Mesa Justice Court if the lower court's declining jurisdiction stands. She'll be forced into a trial with what is considered to be what is potentially illegally obtained evidence. She's going to be forced into a trial in a matter that most likely would be overturned, and therefore would change the trial completely if there would be a trial at all. And that is why her going back down to West Mesa is not an adequate remedy. The state would have two cracks at a case potentially. She would have to win, either win at trial or appeal her loss, and then go through the system again, and then potentially end up back in a second trial.
Isn't that what any defendant faces?
I'm sorry, Your Honor?
Isn't that what any defendant faces?
Except for yes. The short answer to that is yes, except for the fact that in this particular case, we do have what is considered to be a pure first impression matter that the lower court can exercise its discretion to hear. There are numerous cases that the lower courts accept special action jurisdiction on where a defendant could do the same thing, go to court or submit on the record and end up back in front of the lower court again on appeal. So it's not, at least according to the case law and some of the cases from this division, some of these cases have been taken, whether there's an equally plain, speedy, adequate remedy after appeal or not. Our argument to the lower court was not that essentially that Ms. White did not have any remedy whatsoever. It was that she has a matter of first impression of statewide importance on a complete record for the court to decide. The court never even addressed any of those issues and merely ruled on the fact that she could go to trial and appeal if she lost. That was the only thing that was addressed in the ruling from the lower court. The lower court believed somehow that we had stated that going to trial and or that an appeal was not a speedy enough remedy. That was never addressed in our brief. We didn't allege that in our petition to the lower court. We did urge the lower court to exercise its jurisdiction based on its ability to use its discretion to take the case based on the importance of the case and the fact that there is no guidance out there on this particular matter.
Thank you.
Thank you.
Daniel Strange, I'm with the Maricopa County Attorney's Office representing the state and the real party in interest in this case. May it please the court, I'd like to address today three main errors that appellant has made in their briefs. The first being they requested review beyond that which is appropriate. They erred in their definition of abuse of discretion, and they have incorrectly framed the issue that is actually present in this case. The standard of review in this case, appropriate standard of review, is set forth on page 6 of the opening brief of the appellant. It cites Files v. Bernal. Also, I supplemented last Thursday Bill Agoti v. Thornycraft, which is the source of the quote in Files v. Bernal. And it sets forth, if the Superior Court declines jurisdiction of the special action and does not rule on the merits, we determine only whether the court abused its discretion in declining jurisdiction. As I said, that's the correct standard of review. However, on page 18 of the opening brief, the appellant then goes further and asks this court to review this case on the merits. Of course, that would be inappropriate under this court's jurisprudence.
It might be pertinent to our review of the trial court's or the Superior Court's discretionary call for us to understand the issue and if the issue is truly one that calls for special attention.
I believe that the facts of this case are important for just that purpose, and it does go to the merits. My point was that,
without necessarily ruling on the merits, if we thought it was a novel issue, as Petitioner's Counsel asserts, that at least involves some consideration of the merits of the argument, I suppose.
It does, and I don't contest that the merits are important for that purpose. My point is that they actually asked this court to overturn the lower court's ruling on page 18 in their conclusion, and that would be inappropriate for this court to do. Not that this court should not consider the merits. I apologize if I wasn't clear. Second, abuse of discretion, also on page 6. They quote Files v. Bernal, and they set forth the correct standard that abuse of discretion is where the record fails to provide substantial support for the decision of the court. However, on the very next page, they state that a court abuses its discretion by its ruling not providing substantial support. And that's patently false. It is the record which must provide substantial support. A court, as this case, Judge McLennan in the Superior Court decided to give some basis for his ruling. However, he is not required to, and he could have simply declined jurisdiction. That does not mean that that would have been abuse of discretion.
I mean, that's pretty much what we usually do.
And yes, that is correct. So the question is, does the record in this case, and that is where the merits of the case or the facts become important, does the record provide substantial support that the issue presented is not appropriate for special action jurisdiction? So then the question becomes, what is the issue? And the issue is phrased a number of different ways throughout opening brief. At one point they say it's under what circumstances an officer may extend the scope of a traffic stop into a field sobriety search. That's on page 11 of the brief. However, that question was answered in 1986 in Blake. It's when there's reasonable suspicion based on specific articulable facts that the driver is intoxicated. So what is the issue in this case? The actual issue before the Superior Court in this case.
Well, did Blake, I assume, I haven't read it in a while, but I assume it was a traffic stop based on erratic driving, right? That's the usual DUI kind of scenario, right?
It was a traffic stop based on meandering in the person's lane, and when the officer approached, there was an odor of alcohol.
Well, I mean, in this case, wasn't the reasonable suspicion for the stop the windows?
The reasonable suspicion for the initial traffic stop was overly tinted windows, yes.
Right, so that just establishes the officer's authority to detain the person while he undertakes whatever business he's got. And if in the course of that, he discovers some indicators of potential, the person potentially being under the influence, I mean, I guess that would be the issue. Do you have to have separate reasonable suspicion for that after you already have a valid reasonable suspicion detention?
Well, that is the issue is, do we need reasonable suspicion? But both parties agree that the officer needs reasonable suspicion, not for the purpose of the traffic stop, but that the person is intoxicated, or a reasonable suspicion, impairment, or intoxicated.
He has to have more reasonable suspicion than what was requisite for the initial stop to do a
In this case, yes, because the purpose of the initial stop, the reasonable suspicion, was based on the overly tinted windows. So yes, the state would agree that that is not reasonable suspicion to proceed with field sobriety tests. And the officer testified at the hearing that is not why he proceeded with the field sobriety tests. So the question...
So you're phrasing it in terms of what's required to extend a stop for tinted windows to extend it into a DUI investigation?
Well, I don't think it has to be that specific for tinted windows, but a reasonable suspicion stop based on other circumstances. and to then begin or extend that stop to do, in this case, field sobriety tests, which is what was done in this case. So what facts, articulable facts, would give the officer reasonable suspicion to begin that new criminal investigation? We all agree that the standard is reasonable suspicion. So the issue before this court is, or before the Superior Court, are the facts presented here sufficient to constitute reasonable suspicion that the driver was intoxicated or impaired? And that is the only issue. So the problem then becomes, is that an issue appropriate for special action jurisdiction? Now, today, counsel argued that they did not, in their special action, argue that there was no equal remedy, and that is incorrect. On page 7, at the top, line 1 of the special action petition, it states, a denial on motion to suppress leaves no other remedy by appeal. Citing State, Ex Rel. Montgomery v. Witten, and King v. Superior Court. Neither of those cases involve a special action such as this, and King v. Superior Court is a civil case. So for them to stand here now and say that they did not argue that there was no equal remedy is incorrect. They did.
Counsel, so if Ms. White did get convicted, she could appeal that and raise the suppression issue, correct?
Correct. Yes, she absolutely can appeal that, which they are admitting now, but at the time of the petition for special action, they claim differently, and that appears why the Superior Court would address that issue specifically in the minute entry declining jurisdiction.
A question I have is, what will occur at trial that will add to the understanding of the suppression issue? I mean, once the motion to suppress is denied, then the issue's ripe for review, correct? I mean, there's nothing that will happen after that that will inform the trial court or inform the Superior Court or us.
Well, Your Honor,
on that issue.
I believe that it could be right, but in this case, in particular, I believe that there's...
You could have an acquittal.
Absolutely. I believe that there is something important in the facts. It was not raised as part of the record, but based on the police reports, we do know that 2 other officers did arrive at this traffic stop. The Justice Court judge in his minute entry declining their motion said, it appears that this officer did not avail himself well in this hearing, that he was not very articulate. So the fact is that given the record that was made, which was somewhat poorly done by both parties, a trial would provide other facts as to what was occurring at that traffic stop.
Well, but I thought we reviewed suppression issues based on the record that existed at the time of the ruling on the suppression.
Absolutely, Your Honor. I was just addressing what could come up at the trial. You had asked me what would come up at the trial.
And my question is, can the trial evidence be considered on a suppression issue?
I don't think that it should. I'm just saying that there was other evidence that could be presented in this case that was not in the hearing. And we're not suggesting that any court would consider that on appeal, but I was just addressing your question. However, I would note that while any case where a motion to suppress is denied could be taken to appeal, that's not the system. And the special action is a extraordinary solution. It's an extraordinary step to take, and that's why the rules of civil or special action procedure actually require that you have no equally plain, speedy, or adequate remedy. Now, the courts have exceeded that somewhat in certain extreme cases when there is a matter of first impression or a matter of statewide importance. I'd like to address those 2 things with my remaining time.
Sure.
We don't disagree that this is these facts are a matter of first impression. These are unusual facts, and to our knowledge, they have not arisen in a case prior to this exact set of facts. However, they are unlikely, just as they have not arisen before, they are unlikely to arise again. And we would note that it's certainly unlikely to arise in the course of the quick trial that could happen in this case and a pursuant appeal. So, in that sense, it is not an extraordinary matter of first impression. It only affects this case. It is fact specific.
And that purported novelty is what?
Just the odd set of facts. The fact that the officer was at the gas station, heard the revving engine, saw the driver quickly leave, the driver's response to why she was pulled over by stating she was driving like a bitch and attempting to hand the officer her keys. Those are the facts that are unusual, and those are the facts that are to be considered in determining whether or not there was reasonable suspicion. So then that leaves an issue of statewide importance. Now, appellant has said that this is an issue of statewide importance because it's DUI related. In their petition, or their opening brief, they cite two cases in support of how DUI cases are routinely handled by the courts of appeals. And there's a problem with both of those. The first is Verberg. They say that that was because it was DUI, but in fact, in Verberg, there was a motion to suppress. It was denied. They went to trial, and they appealed. And Verberg was before the Court of Appeals in that case because they had no equally plain speedy remedy to review the Superior Court appellate case. Because, of course, you cannot review those. It has to be done through special action. So Verberg was not because it was a DUI. Verberg, they actually went through the procedure that Superior Court said they should in this case, and it was not reviewed because of its subject matter. It was reviewed because there was no equally plain, speedy, adequate remedy. The other case is Butler.
You mean because the appeal was the Superior Court and there's no further appeal?
Correct. Butler was about a juvenile who smoked marijuana before coming to school and was charged with a DUI, and in that sense it's a DUI-related case. However, jurisdiction was appropriate for two other reasons. One, that juvenile was about to, or had already by the time of the Court of Appeals and Supreme Court decisions, turned 18. So there was an issue because he was a juvenile and the jurisdiction of the juvenile court over him, as that case was more appropriate for special action, instances that aren't here. As well as the fact that the actual question that was addressed by the court in that case was what was required to make consent to a Fourth Amendment search by a juvenile voluntary. The fact that the consent search in this case was an implied consent search for a blood draw is irrelevant. They went on a broader issue, and the majority of that opinion only addresses that question. So the fact is that the appellant has cited no cases that were accepted purely because they are a DUI case, and there are no cases, and there are no particular crimes that make something an issue of statewide importance. This is an issue of importance only to this case. As the court noted earlier, no written opinion of the Superior Court as the lower court of appeals would be usable in any other case, so it would not serve the purpose of expanding jurisprudence in this area. Just like to end by noting that this is not, as I've said, the issue presented is case-specific, not likely to reoccur. While it is a matter of first impression, it is not an extraordinary matter of first impression and not a legal matter of first impression. And it is not a matter of statewide importance. For that reason, I would ask this court to deny appellate's request for relief and uphold the Superior Court's denial of jurisdiction.
Thank you.
Thank you.
With regard to the discrepancy in petitioner's brief, appellant's brief, regarding record versus ruling, whether it's the record or the ruling, I would submit to the court that there is no additional substantial information that supports the lower court's denial of jurisdiction, however. With regard to the ruling from the lower court, my comments earlier to this court were that there was some language in there that appellant was claiming that an appeal was not speedy enough. That claim was never made by appellant. What appellant did claim, however, was that this was a matter of first impression. It was a legal issue. We had a complete record, and it was of statewide importance. It is cited in appellant's brief, State v. Moss, which is a case that defendant filed a special action on. Actually, it was defendant filed a motion to suppress the breath test results. This was a Division I case from 1993, a DUI. And that motion was denied. And then defendant filed a special action requesting special action review to Division I. Jurisdiction was taken given the fact that this issue has great statewide impact on law enforcement officers and defendants in DUI cases. And the state agreed in that case, unlike in this case, for judicial economy reasons. We would also point out for judicial economy reasons that bringing the matter before the lower court of appeals for judicial economy reasons alone in answering that question, which is not answered in Arizona case law, what minimum set of facts do you need to extend a traffic stop, whether it be a California stop, whether it be tinted windows or anything else, but when a police officer comes into contact with an individual, what minimum set of standard facts or the other cases that are cited in our brief from other states, there is guidance in those states. And what is clear and what runs consistent through those cases where the courts have found that, yes, the officer did have reasonable suspicion to extend this stop beyond what it initially started as, is some modicum, some indicia of either intoxication, of inhalation, consumption, and those things would include things like a moderate or an odor of alcohol of some type, bloodshot, watery eyes, slurred speech, difficulty with balance or sway, fumbling with something, not being able to understand questions, usually multiple indicia of impairment. In this particular case, all we have are tinted windows, loud music, revving an engine, pulling out of a parking lot quickly, and then a statement in response to something from the officer that I was driving like a bitch, and then she tries to hand him her keys. That's it. Whether upon the totality of the circumstances or whether upon each individual fact, there is nothing here that would indicate somebody's just been drinking. And that's the question. And that is something that can happen in other cases as well. And it doesn't just turn into just an HGN test and maybe a walk and turn. It potentially turns into being handcuffed, transported, having your picture taken, fingerprinted, and a needle stuck in your arm.
Are you saying there are no reasonable inferences that can be drawn from the defendant's statement to the officer and her action of handing the keys to him?
I'm not saying that there's absolutely nothing, but to jump to you've been drinking when the officer didn't even ask the question, have you had anything to drink? But it could indicate a lot of things.
Such as?
Somebody's in a bad mood. Maybe they've been, specifically with regard to the keys, Your Honor, given what had been going on at the time in the news with different instances of confrontations between motorists and police officers, maybe somebody didn't want to have any type of a confrontation whatsoever and decided, here's my keys, I'm not going anywhere, I'm not trying to get away. But in terms of leading directly to drinking alcohol or something like that, I would say no. So we do go back to relying upon the fact that this case is ripe. It's ripe for review. The record was complete.
Counsel, I take it, and as I explored with your opposing counsel, there's nothing that would occur at the trial that would inform any court on the issue, on the suppression issue, correct?
I'm sorry, Your Honor, can you
There's
repeat?
nothing that would occur at a subsequent trial that would inform any court on the suppression issue. The record on the suppression issue is what it is, correct?
I agree, Your Honor. There is nothing that counsel was mentioning things that aren't in the record, and that the fact that there were other police officers on scene. However, it's quite customary for any backup officer to basically not be able to give any testimony other than to say, I was there to secure the scene. There was one police report that was written. It was written by DPS officer Ortiz. That's it. Nothing else has been disclosed to defendant. Officer Ortiz is the only officer that was there that was conducting an investigation. With regard to any other indicia and any additional information that would come out at trial, the officer's married to that report, and he's married to the transcript from the hearing, and the transcript from the motor vehicle department hearing, and the transcript from the interview. And everything comes down quite clear that those 4 or 5 different facts, that's the entire universe of facts that the officer had to work with regard to whether or not he was going to broaden the scope of this stop, lengthen the time of the stop, and as this court's well aware, under State v. Verberg, this is a legal request for the officer to ask to look at somebody's eyes. It wasn't a consensual, I'm going to stand here and allow you to look at my eyes. She had no right to leave. And she has no right to refuse him either. So, sending this back to trial would not be the best use of the court's time. There's nothing more to learn at the lower court. It is ripe for review, and given the fact that the record does not provide substantial definition or a description of why special action jurisdiction was declined for the statewide importance and the other issues of first impression, we request that this court remand it back to the lower court to make a ruling on the merits.
Thank you, counsel. We appreciate both of your arguments today. We'll take the matter under advisement, and we'll issue a written decision in due course. We'll sit at recess, and we'll allow counsel for the next case to come forward. We stand adjourned.